Nau mai haere mai, tēnā koutou katoa. My name's Gwen Drewitt. I'm Special Counsel at Lane Neave. I'm speaking to here from Christchurch, our office in Christchurch. We are a full service law firm, and I'm joined by Andrew Shaw, Managing Partner, who's also in Christchurch with me, Fiona McMillan up in our Auckland office, and Andy Bell in our Wellington office. We also have an office in Queenstown and are delighted to speak to you today about redundancies. So, Andrew, I'm going to start with you. I personally feel like we've been speaking about redundancies since COVID. Can you give us any insight on why we're still speaking about redundancies now?
Yeah, thanks, Gwen. Kia ora, everybody. Look, the COVID brought out some unusual economic factors, and I think a lot of us thought, wow, a lot of people are going to be made redundant. And then that quickly turned around when there was a lack of staff. So I think there was a bit of a false start there. The economy obviously is in a bit of a different space at the moment. The IMF have come along and spoken about what we need to do in New Zealand, which includes tightening of our budget coming up. So at the moment, there are still people talking about redundancies, but with that sort of background of potential recessions and COVID and so on, it's just an uncertain time. I think we're starting to see now, though, a lot more redundancies, specifically in the construction industry. It was interesting, the CEO from Warehouse was on TV the other day, and he said he thought a lot more people were spending money on entertainment and travel than they were on household goods. So what I think you'll see is redundancies in certain areas and perhaps not in other areas. Will it increase in the near future? I suspect it will, both with government tightening its own spending in the public sector, but also in the retail area where, for example, it's a pretty tough time at the moment, certainly in the construction area. And I see a number of professional service firms overseas also restructuring as well. So yeah, I think we'll see a lot more coming up, but with that background, it's just been a very uncertain time.
Thank you. And Andy, let's start with the basics then. When we're talking about a redundancy situation, what are we actually referring to?
Yeah, thanks, Gwen. So there was a definition that came out of the cases, I think, early 90s, and you see that sort of reverberating through employment agreements, and that's where a role or a position is surplus to an employer's requirements. So that was that comes out of some of the old case law, and it has been picked up, that would be the common usage of the term redundancy now, and it does emerge from those cases. There are sort of three distinct situations where you see a redundancy emerge, and that's where a role is just simply not needed anymore. So that would be the first situation, but probably the most common situation is slightly different, and that's when the business's requirements change a lot, and then the business is faced with looking at its roles and saying, well, do these meet our needs, or do they need to change? So what you can't do to your workers is say, hey, we're gonna wholesale change your role, and you must adopt that. That's not possible. That's a unilateral change. But what you can do is create another position that meets your needs, that is substantially different to existing positions. And the creation of that new position will make the old position superfluous to the employer's needs. So the trap there is that they actually do have to be quite different. I think that the test in the cases, it's always the way with some of these cases, is a little bit tricky and hard to actually say, well, what does that mean in practice, and introduce it into a workplace? And that's that the continuity of employment is broken by the change. So lots of professionals over the years have used more of a shorthand approach to it and really asked the question, how different is this role? And there's a rule that's emerged that to be a new role that makes an old role superfluous, it's got to be about 80% different, but there's a range of views in that. Some people will tell you about 70% different, but none of that actually reflects the test in the case law. The test is, well, if you made these changes, does it break the continuity in the existing role if you made those changes to the role? So it's a difficult test, and that's why it's always quite good to get another pair of eyes on a professional when you're saying, is this role actually a different role?
Mm-hmm. And that's, in my experience, that's where we quite often will sit and compare two job descriptions, but also ask a number of perhaps stupid questions because we don't know the industry, just to make sure that we're understanding the differences between two roles. So it is a highly practical inquiry in my experience.
And it does also rely on those role descriptions being good representations of what the role entails. And I think that's always my advice, is when I get a set of role descriptions, I say, well, look, have you tested that these actually bear out the reality of the roles, or if the roles evolved and changed over time?
That actually segues into a question, an interesting question we got in just in advance of the webinar. I'll open it up to the whole panel, but questions come in terms of, when you go into a restructure, it's not uncommon for a job description to be out of date, or a position description. Do you think it's reasonable for an employer to tweak job descriptions in advance of a restructure? Does that risk showing predetermination?
Look, I think you actually have to do it out of fairness, because if you're going to say to a person, I think your role is redundant, the exercise of actually examining the role and seeing what it does and that it reflects the reality, that the role description reflects the reality, is important. And I think that the decision's not going to come as to whether to make someone redundant from the fact that you're just tweaking role descriptions. The decision is going to be, do we need the role as it stands? So I think you actually, rather than see it in that framing, you actually need to understand what everybody's doing. And I would say you owe that to the employees across the board, to understand what each role is doing. And look, it might tip your hand somewhat, but it's a necessary evil in my view. But I'm open to suggestions from the rest of the panel.
Yeah, I agree, Andy. I mean, if you're comparing a current role to a proposed role, then you've got to compare what the role actually is. And if you think about a job description, it's in the employment agreement, and an employee may be employed for a significant period of time, with the job naturally changing and the job description not changing. So I think it's got to be what the role is actually doing. And in part, you could look to agree with the employee about, well, what does this role actually mean? And then you can go on and look at a proposed role from there.
It could even be a step in the process if there's not pressure on the timeline of the redundancy. One of the things that a professional might do, faced with a bunch of role descriptions that are out of date, is say, well, part of the process is first we're going to look at everybody's roles and make sure we know what everybody's doing. And I think that if you're open and transparent about that, then you really can't be criticised.
Yeah, it would show utmost good faith if you're honest with people about why you're reviewing their position descriptions. Thank you. So, Fee, turning to you, what are the legal standards that an employer is expected to meet when embarking on a restructure and then going through it?
Well, the first one is what you just touched on then, and that's good faith. So Section 4 of the Employment Relations Act requires an employer to act in good faith during these processes. When it comes to restructurings, I think there are two aspects to that. The employer has got an obligation to put an employee on notice at the first possible opportunity that they are aware that there might be changes coming to their role. And the second aspect of that is an employee is entitled to all information that the employer has in front of them when they're making this decision. I think the key Key thing there though is access to that information. You don't necessarily have to email out your company's financial information to every man and his dog. Employees are just entitled to access to it. So we see things like employees are welcome to go to meeting room X at X time to view information, etc. So that's the good faith aspect. The second part of it is if an employer does go through a restructuring process and an employee challenges it, and you all end up in the Employment Relations Authority one day, the authority will look at the process in relation to Section 103A of the Employment Relations Act. So that test is whether the employer's actions and how the employer acted were what a fair and reasonable employer could have done in all the circumstances at the time that the dismissal or the action occurred. And I guess the last thing I talk about the Employment Relations Authority, if you end up in the authority or the employment court defending your process, you've really got to show two things. One, that you had a justifiable business case to make the decisions that you did make, and that you also followed a really robust process. Historically, the authority and court's position has always been that you can run your business the way you like, and they won't necessarily look in so much detail about that, but they'll really investigate the process. I would suggest that has shifted over time. I think the authority and the court are just as thorough in relation to both aspects of your process, but you do have to tick both boxes. You must have the business case, and you must have followed a really robust process.
Thank you. And it just makes me think I've got a situation at the moment where I'm acting for an individual employed by an Australian company. And if we have any Australian listeners, please heed Fiona's advice and note that it's not okay to just have a meeting with someone over Zoom and make them redundant on the spot without any form of process. We get those cases every now and then, and it's great fun educating our Australian colleagues on the law here. Thanks, Fee. So, Andrew, Fee talked about good faith and the process that employers are required to follow in terms of the legal test that they're expected to meet. Practically, can you talk us through a sound redundancy process?
Yeah, thanks, Gwen. So look, redundancy is probably one of the most litigious areas in employment law. And in my experience, I think that's because people lose their roles and they haven't done anything wrong. It is the environment, the company's financial position, or whatever. So it's vital you get it right. Fee talked about the business case, and that is the starting point. You develop that business case to assure yourself that you've got a good, genuine commercial reason for doing what you want to do. Once you have that, it really depends on the number of people who are being made redundant. I've been involved in redundancies where a company's making one person redundant, so it's a lot more one-on-one. Whereas I've been involved in a number of redundancies where 500 plus people have been made redundant, and so that becomes quite different. If it's a one-on-one, I suggest getting your business case together, having a first what we call at-risk or heads-up meeting, giving the employee all the information, just explaining it a little bit, but not expecting a response. Then allowing them a sufficient period of time, around about a week, for them to come back and sit down and provide feedback to your proposal. From there, you might want to do a little bit more investigation. Otherwise, you give it a period of time where you consider their feedback and make your decision. And after that, you start looking at issues such as, can I redeploy them? If it's a large-scale redundancy, we typically do it by way of a meeting to begin with. We have packs ready for the employees to pick up at the end. There's typically a PowerPoint. And to the level where if it's quite a significant portion of a company, you'll have experts on hand, a counsellor, budget advisory, career advisory people on hand to talk to the employees because they're quite shocked by this news. So for me, redundancy process is really so a number of steps along the way, where full consultation with the employees and full amounts of information, as Fiona indicated, Section 4 of the Act requires good faith for there to be full information provided. Some of the practicalities to think about is where there's a large number of people, you can't meet with every individual one for their feedback. So have a feedback provided to a specific email address, meet with them as a group if possible. Often people may not want to provide feedback, but you have to allow that opportunity. So each case is different. Always provide the information, always have a good business case, and always consult with employees throughout, and be ready to change your view if necessary.
And just a follow-on question there, do employees have the right to be represented through this process? And at what point would you expect to meet a lawyer representing an employee?
Yeah. So the answer is yes, because their role may be terminated as a result of the process, they're entitled to be represented. At what point? At a point where you're obtaining information from them that could go to the decision to terminate. So not necessary in my view for the at-risk meeting, because you're not actually asking them for much, you're kind of explaining the process. If they wanted to bring somebody along, then there's no issue with that. But certainly at the feedback meeting and beyond that, they should be represented or allowed the opportunity to be represented.
Thank you. Andy, Andrew mentioned the business case in terms of a redundancy process. Can you talk us through what you'd recommend is included in a good business case?
Yeah, and Gwen, I think my colleagues have stressed how important it is, and I would just reiterate that it all really does hang on that business case. And I think that they're often looked at quite lightly. And one thing that I would highlight is your business case. It wasn't always this way, but there was a series of cases that say the authority can look at these decisions and they can say, is this reasonable in all the circumstances, the business case? So you can't. There was a time in our history where you could say, well, it's a genuine decision and you can't look behind that, and that's no longer the case. So it needs a lot of care. Just speaking generally, it needs to have the objectives of the change and identify how those objectives are going to close the gap. So if you're saying we need to make this amount of cost saving to make this business viable, you've got to connect the actual structural change to making those savings. You want to also highlight potentially the risks and issues and how those will be addressed. I think you want to also, at this point, show how there might be potential opportunities that the restructure is trying to capture. You'd want to spell those opportunities out. So it really is about setting out a really well thought out, robust, reasoned, and if you're relying on financial aspects, I would say don't leave taking it to the accountant till somebody raises a problem. If it's a financial proposal and it's reliant on the necessity for cost savings or something like that, then test that with your own financial advisors. They should never go out. They should never go out as a loosely formed idea. The other thing that I would add is I think when you're producing the business case and the slides that go to employees, there's this tendency, and we see it all the time, that the slides are full with baffling language and they talk around the point. I think when you're producing this kind of document, your touchstone should always be, I might have to be cross-examined on this in front of an Employment Relations Authority member. Can I justify everything that I've said? And I think speaking plainly and reducing your message down to its kind of purest form is the best way to do it. I mean, I came across one the other day, and it was just a decision to reduce some managers, but it talked about all kinds of things. It even talked about climate change, which had nothing to do with the proposal itself. And I was thinking, well, you know, if you had to take some questions from me on cross-examination on how your business rationale is affected by climate change, you're just not going to be able to do it. So I think all that stuff's got to be avoided. Keep it basic and be well prepared would be my messaging around that.
Yeah, and I think my test is always, if I have to ask too many questions and the proposal doesn't make sense to me, then it needs to be simplified. I think less is more. I always find it helpful if it is a financial business case that you're presenting, it's always helpful to set out how you've tried to reduce costs already, or costs that you've already reduced, rather than being seen to be targeting employees straight off the bat. Yeah, but thank you for that. Sophie, if we look at the proposal document itself, what do you need to include in that for it to meet the test of good faith?
Yeah, so Gwen, at a high level, I think what you need in there is what your current structure is and what your proposed structure is. I think there is this presumption that everyone in the workplace knows what the current structure is. Potentially not. If there have been previous changes, if someone's fairly new to the organisation, they might not know what the exact current structure looks like. So the current structure, what you are proposing to do to the current structure, you might add in there as well what your selection process might look like if there is a selection process. So I think we're going to talk about this a little bit later on, but if you've got 10 plumbers and you're looking at going down to 5 plumbers, you might be asking for 2 lots of feedback. One, your proposal around going from 10 to 5, and how you're going to go through that process to pick those 5 plumbers. But we'll probably talk about that a little bit later on. I think you want to outline what your process is going to look like, so what the rough timelines are going to be. I don't think you want hard and fast dates in there as to when you're expecting feedback by and when changes will be implemented. I think you've always got to allow yourself some wriggle room. I think you've got to make it very clear to the employees what the worst case scenario of the proposal is for them. So for some people, it will be if they are not selected, or if there are no redeployment opportunities available, they might be made redundant. But last, but especially not least, what support is available to them as they work through this process. And echoing what you said before around everyone is entitled to a representative and or a support person as you all work through the process. I just want to, I guess, echo the comments we just had before about the language that you use in these documents. I think we see a lot of business jargon, things like streamlined, creating efficiencies, we're looking to consolidate. That doesn't really mean a lot. So I agree with what Gwen and Andy have just said. Less is more, and just really use really simple language about what your problem is and what you're trying to achieve in the proposal.
Thanks, Fee. And just a follow-on question from that, Andrew touched on it, but what are the options for actually presenting a proposal? Because for employees, that's the first time they learn that potentially their jobs are at risk of redundancy. So what are the options there?
Well, it's a bit challenging, and it will depend a little bit on the size of the restructuring, as Andrew has touched on. But what we see happen is one of 2 things. A group of people might be sent a letter or an email saying, look, we are about to embark on a process which might result in some changes to your role. We want to have a meeting to explain those changes. You're welcome to bring someone with you. The upside of that is people get a heads up. They know what's happening. they get the opportunity to bring someone with them. The downside of that is people spend 48 hours potentially panicking and potentially unnecessarily. The other option is, as Andrew touched on, you can bring someone into your office, explain what the proposal is, make it clear you're not expecting them to give any comment that day, and they're welcome to go away, get some representation or support, and then provide some feedback on it at the next step. So there are two schools of thought on it, but it will depend a lot, I think, on the size of the restructuring. And as Andrew's touched on, sometimes these can be simple proposals that involve one or two people, and it might be a letter. If it's involving tens of people, hundreds of people, it might be a PowerPoint, it might be an information pack that's held in quite large group meetings. So it is a little bit fact dependent in my view.
Perfect, thank you. So Andrew, once the proposal has been presented, what are the steps an employer should be moving to after that?
Yeah, so a number of things can occur. Obviously, employees who think their job is at risk will be a little bit anxious, so offering EAP is important. Some employees might feel there's not enough information, so be ready to provide information to those employees as requested. There may be a number of questions, and what we like to do is where there are a number of questions asked, I think it's important that the employer picks up those questions and puts them into a frequently asked question document and sends it out to the employees, recognizing there might be some privacy aspects, but if one person asks a question, it might be relevant to others. So I would put that out to employees. Some employees may take sick leave, and of course they're entitled to, and I'm not sure you need to race out and ask them to get a medical certificate because they're pretty upset. So all those things can occur immediately after the proposal is presented. Then you go to the feedback meeting. And the feedback meeting really is obtaining information from the employees or their representatives. And again, a lot of questions might arise out of that, or more investigation may arise. So you do that post the feedback meeting, then you go to the decision meeting. And I think we'll talk soon about the likes of selection process and redeployment. But they're basically the steps for me after the proposal's been given.
In my experience, to show an employee that you've genuinely considered their feedback, the key is responding to each one of their comments. And in some situations, depending on the person you're dealing with, those comments can go for pages and pages. Do you always respond to feedback individually?
Not always. If it's a large redundancy in terms of number of people, I think you do it on a general basis. One-on-one, yeah, obviously you'll respond individually. But I think it's really crucial that you must respond, because good faith requires you to be constructive and responsive. So if a question's asked, you need to respond.
Perfect. So Andy, we've presented the proposal, we've been through our period of feedback. What's the next step in a redundancy process?
Yeah, thanks, Gwen. So the next step is probably D-Day, decision day. And this is the step where you're advising people of what the structure is going to look like, and that necessarily entails probably telling people that their role is going to be disestablished. So this is probably that area where if you get it wrong, this is where you're going to get some grievances emerging about your process. And I think my North Star with this stuff is really just trying to be as sensitive as possible to the people that are having their roles disestablished. And generally, you've got two tiers of people when you come to making your decision. You've got the people that their roles are disestablished, and if they can't be redeployed, they're probably looking down the barrel of a redundancy. And you've got those that are affected, but they're in the margins. They might have reporting line changes or different managers coming in ahead of them, and you owe these two sets of people different duties of care, in my view. So the people that are losing the role, those are the people that you've got to have that extra layer of sensitivity. So I would recommend that you're tailoring the process potentially to get to your people that are really deeply affected first, and you would do that on an individual basis if you can at all possibly do it. So I think those people, it would be a personal letter, it would be a meeting and a sit down, and a discussion where you're prepared to answer some of their questions if they raise them. And you probably at that point with them in person if you can, if there's options that are obvious for redeployment, map out that to them either in the letter or in the meeting, or both preferably, saying, well, look, your role has been disestablished, but look, there are these options and this is the process and this is the timeline, so that they know that that's all in place. Also, because this is the point where you've really created the biggest shock. There's people that probably thought that their feedback might mean that they might be safe. So this is the point where you're probably reiterating the availability of EAP and facilitating that if you can. So your wider group, you can probably, you can be less rigid there, and you can probably deal with that by a big group meeting, or alternatively releasing a document to everybody that's affected only marginally, so reporting lines and that kind of thing. But where you're going to get your grievances is the group that's being disestablished, so that's where your care's got to go.
Thank you. And so selection processes, Fee, you mentioned them earlier, and I was interested in your comment around potentially including a selection process for feedback in the proposal document right from the outset. I'm aware that there are two schools of thoughts in terms of at what point you introduce a selection process. Can you talk to us about your view, and also what is the selection process?
Yeah, and I think, Gwen, that's a good point. So we're all on the same page. You often hear people talk about how their friend is having to apply for their old job, or they have to apply for their current job. That's not quite right legally. This is a selection process situation. So in restructuring processes, you see selection processes generally come up in one of two ways. So the first is decreasing the number of people who do the exact same thing. So I've already touched on, you might have 10 plumbers. You think you've only got enough work for 5 plumbers moving forward. The other time you see selection processes come in is perhaps you disestablish 2 or 3 roles. You're creating one new role, and all of the people who you've disestablished, they are legally entitled to be automatically redeployed to that new role. So you need to go through a selection process to work out who's going to get that new role. I guess when you introduce the selection process, as you said, Gwen, there are two schools of thought, and I'm not overly passionate either way. I think it depends on the amount of time you have, and I think as long as it is worded correctly, you will be legally compliant. So the first way to do it is you could say, right, our proposal is to go from 10 plumbers to 5. We want your feedback on our proposal to go from 10 to 5. And we also want your feedback on, if we do that, this is the selection criteria we're looking at using. Do you think that's the right selection criteria? The other way to do it is a bit of a 2-step process. So you could initially get feedback on going from 10 to 5 plumbers. After getting feedback, you might make your decision to only have 5 plumbers moving forward. Then you go out to those 10 plumbers and say, right, we've made that decision to go from 10 to 5. This is the selection criteria we're looking at using. Can we have your feedback on that before we apply it? So, as I said, I'm actually not overly passionate about which way you do it, as long as it's worded correctly. Either way, then I think you are completely fine.
From my experience, I agree with you. There's nothing wrong with either of them, but I think we used to shy away from putting the selection criteria in the proposal right at the beginning, the fear of fueling an argument that the process was predetermined, that you're not consulting over us about whether we should reduce from 10 to 2 plumbers. You've actually made that decision. This is just about the selection process. But especially with COVID, in my experience, that it was reasonable to include the selection process within the proposal document, and we didn't experience any pushback. It was just a more streamlined process in my experience.
I agree.
I like to have it in the proposal because A, it's more streamlined, but B, the attention of the employees is usually on the substantive proposal, so you tend to get less pushback on the criteria. So you can put relatively general criteria in that proposal, and everybody's focus is on the proposal itself for the roles that are going, and everybody overlooks the criteria, and ultimately you get exactly the criteria you want without any pushback. Whereas I think if you give them another bite at the criteria, having just told them that you're disestablishing roles, then your criteria get really attacked. So if you want to slide your criteria through, I put it in the proposal.
Crikey, Andrew, I thought we were the sneaky ones, but clearly not.
No.
Great tip, Andy. Talk to me, Fee, about selection criteria versus an interview process.
So my view is, and Andy, Andrew, and Gwen, you might have a different view, and this is where this whole applying for your current job language comes from. I think an interview can be one of the criteria, but I don't think it can be the sole criteria. I think you need to keep your criteria as objective as you possibly can. But at the same time, I'm quite realistic about the fact that sometimes some of the more subjective things are actually the things that are more important to you as an employer, and you want your 5 plumbers to have those abilities. So my view is, I think an interview can form one of your criteria, but if you're just saying, right, 10 plumbers, I'm going to interview all of you and pick my top 5, I think you are opening yourself up to scrutiny.
Yeah, Fee, if you have a selection panel where the managers on the panel know the people well, the potential for an interview to me is a bit superfluous. You just don't need it. But it's really important to understand not just the skills and abilities that an employee holds in the current role, but what they held in a previous role. For example, if it's a forklift driving role and somebody doesn't do much forklift work in the current role, they may have done a lot in the previous role, and that becomes relevant. So yeah, interview if you don't know them well, but if you've got a selection panel that knows them well, I don't think you need an interview.
To me, a potential complication occurs where you've got your existing employees who are facing redundancy, but then you decide that you're going to advertise a role externally, which would then necessitate an interview process with the external person. And how do you then treat everyone fairly? That's quite often the case with more senior disestablishments, and perhaps the people in the roles are not quite up to scratch, but can throw their hat in the ring. In that situation, I think an interview is the only way to go. But correct me if I'm wrong.
Look, I agree, but we've got to remember that you can only open it up to external parties if the people internally are not entitled to be automatically redeployed to the new role. So if you look at your 10 to 5 plumbers, you sure as heck can't advertise for more plumbers and put them in the mix. If you have 3 disestablished roles and created a new role, in my view, you can only open it up to external parties if these 3 people are actually not entitled to be automatically redeployed to that new role. But Gwen, I completely agree with you. Sometimes the more senior the role, it is more likely that automatic redeployment might not be at play. Then you can open it up to external parties, and an interview is a really important part of that process.
And we'll come on to redeployment in a minute. So thank you, Fee. Got a great question in advance of the webinar in terms of the right of, let's say, your plumbers, your 10 plumbers, to see the scores of their colleagues and how you go about protecting privacy. Does anyone want to comment on that?
So I guess from my end, what we're all talking about here was there was a decision involving Massey Uni many years ago now, I think it was about 2011, where a gentleman went through a selection process, and he said that he needed to see the other people's scores in relation to the criteria for him to be able to meaningfully provide feedback. The employment court agreed with him, which was quite a horrifying moment for employment and privacy lawyers at that time. The Employment Relations Act was subsequently watered down a little bit to essentially say, yes, employees are entitled to all information in these processes, except when other people's confidential information is to be handed around. I guess a bit of a middle ground that a lot of employers have landed at is they might provide the 10 plumbers all of the information around everyone's scores in relation to the selection criteria, but they might redact the names of the 10 plumbers. My view is that's a bit of a useless halfway house. It's definitely a useless halfway house when you are going from 2 to 1 people. Redacting names then is quite pointless at that point. I've seen a few employers actually have conversations with those 2 employees and say, look, how do you want to do this? Are you actually quite comfortable with your scores going to each other? So you're in a position to provide feedback on that. But I accept that this is pretty tricky, and Andy, Andrew, or Gwen, you might have a different view or have some more practical ideas around how to deal with this issue.
I always go for the consent option fee. Just talk to the employees. How do you want to deal with this? Let's all agree and then move forward on that basis, recognising that if an employee consents their personal information being released, then there's no breach of privacy. What do you think, Andy?
Yeah, if it's a big pool, I think I tend to provide the data with the names redacted, and I think that's not a bad way to do it, because generally when people they request the scoring, what they're trying to do is they're attacking one part of the scoring and saying, well, look, I should have been ahead and made you cut. So I think that actually generally gives people enough information that they can advance that kind of argument. But I think you're right, when it's down to just 2 or 3 people, the people are probably identifiable from the scoring because they all know each other and know strengths and weaknesses. And I think the only way to deal with that is consent.
Gwen, before you move on, I just want to touch on something Andrew said before. Andrew's completely right. This area of law is probably one of the more litigious areas because people are losing their jobs through no fault of their own. But it gets extra litigious when people find out that some of their peers are keeping their jobs and they're losing theirs. It adds an even further layer, I guess, of personal attack. So, and I guess where employers do go wrong in these processes is around this selection issue and this redeployment issue that I know you're going to touch on later on, Gwen.
Yeah. And just something I picked up on there, my advice would be to provide scores on a tentative basis, because that gives the employees the chance to effectively argue that they should move up the ranks. If you don't do that, then you risk breaching good faith, and ultimately any decision to make that person redundant could be challenged on that basis. You know, it's a fraught area. Andrew, we've all mentioned, or all of you've mentioned, redeployment in your responses. We haven't touched on that yet. Can you talk to us about the obligation to redeploy someone whose role is at risk of redundancy?
Yeah. So look, I mean, this is one of the most litigious areas of employment law, and within the most litigious area, redeployment is probably one of the more common claims you'll see. There's a couple of factors here. So the first is that you must consider redeployment. If somebody is going to lose, if the role is going to be made redundant, then the person is still employed by you, but you have to decide whether you can redeploy them. If you can't, then they're made redundant. So the starting point is that if the job is not materially different, so the new role created is not materially different, you must give the employee that role. And often what you find is employers shake up a role a little bit, make it a little bit different, the employee must get that role. If it is a lesser role out there, you know, a role that an employee could do, you must offer it to them, in my view. Now, they may not take it because it may be paid less and it may be a demotion, but certainly offer it to them. It's where there is a role which is a greater role and the employee needs to be upskilled. And this comes from a case some time ago, Wang and Hamilton Multicultural Centre, where an employee was not offered a role that their skill set would allow them to do it, on the basis that the employer felt it was a much greater role. And the question comes down to, what is upskilling? And there's no definition of that. So upskilling, in my view, is when you're promoting someone from one role to another, you must give them time to be able to get into the new role and be able to do it properly. It doesn't mean that you allow someone 3 years to go get a university degree, for example, or a significant period of time to get a skill which they don't have. So for me, redeployment must be looked at every time you look to make a role redundant. If it's a lesser role or not materially different, the employee must be offered that role. If it's a role which they could be upskilled into, they must be offered that role. And again, that's a very grey area. But if it's quite a substantially different role and upskilling would be quite significant, I think you can certainly offer the employee the opportunity to apply for it, but you don't have to offer them their actual role.
Thank you. And I suppose that ties in nicely with Andy's initial description in terms of what a redundancy is versus a restructure, and this, how you determine whether a role is substantially similar or substantially different. We quite often find ourselves assisting employers to justify why they're not appointing someone to a particular role on the basis that it is substantially different. And again, that is a highly factual inquiry that can take some time and will not necessarily be accepted by the employee. Thank you.
Yeah, and I think when often we get the current job description, and back to our previous conversation, hopefully a job description which is accurate and up to date, and you break it down. What are the elements of that job description? What portion of the time does the employee work there? Then you look at the new role, and you know the 80-20 rule's gone, but certainly the material difference is one that you can assess to say, is this an actual new role, and do I allow this employee to apply for it, or is it materially the same, and I must allow them must offer them the role.
And then I had an interesting one where an employee identified a course that they could go on, and I think it would have taken them 3 to 6 months to upskill, which I actually thought was a pretty good argument, because they were doing a similar-ish role, was it reasonable for the employer to say, well, no, I need someone to hit the ground running, rather than continue to employ this person, avoid a redundancy and wait what was arguably not an unreasonable amount of time for them to upskill?
Yeah.
Okay, so Andy, we've all touched on this as well, but redundancies do hit hard. They have a profound impact on employees. What's the type of support you recommend employers have in place to support people through these processes?
There's kind of a suite of things that can be offered that you see commonly offered. So the number one is counselling and EAP counselling, and I think that's really common. You see almost every restructure and redundancy. There's also support with CVs and resumes, and there's lots of providers that actually provide that support as well that you can have available to your employees. There's interview training, so people that perhaps haven't had to be out in the workforce applying for jobs for a long time, that can be quite valuable to people in that situation that have been on staff for a long time. Just career direction and career advice from advisors is another practical thing that can be provided by a lot of contractors. So a lot of my employers have those available to them and going into these kinds of situations. So those are the main ones that I see, Gwen, but my colleagues might have some views about other support that's available as well.
Nothing from me. I think that summed it up.
Yeah, very comprehensive, Andy.
Thank you. And so the final question goes to you, Fee. Is it ever appropriate to ask for volunteers in a redundancy situation, and at what point would you be looking for volunteers?
Yeah, so at a high level, yes, it can be appropriate to do so. My only caveat to that advice is sometimes your individual employment agreements or collective agreements will specify when you can do that, what the process for that is, etc. In my experience, it's quite rare to see this issue covered in an IEA, but it is often in collective employment agreements. So yes, you can do it. Make sure you are adhering to your own rules around when and how you do that. And it can be an incredibly useful tool. We saw a lot of organisations do that in some of the restructurings during the height of the COVID period. And you saw people go, actually, well, hang on, I was actually planning on retiring in 3 months' time anyway. I would hate to see a younger person in the workforce lose their job when I was planning on going in X amount of time anyway. So you saw lots of things like that happen when we were at the peak of COVID. So yes, you can do it, but just check your paperwork.
And I find sometimes a financial incentive always goes a long way if you're prepared to pay some kind of compensation, and always reserve the right to consider applications for volunteers, I would say, just in case you have a flood of employees and you're not left with anyone to actually do the work.
And I guess, sorry, Gwen, I was just going to say one thing to add to that. I think in the current environment, I think it is going to be less likely for people to put their hand up for voluntary redundancy. I think potentially where there was some form of financial incentive, you have seen people go, well, yeah, I will take X amount of money and I actually back myself to walk down the road and get another job in a month's time anyway. But I just don't think we're quite in that environment at the moment. So I don't know if people will jump on this as much at the moment.
Thanks, Fee. Thank you to the panel and thank you all for joining us. That's the end of our webinar. If there are any questions that have come through since we've been talking, we'll make sure to come back to you. Otherwise, have a great day.
Great.
Thanks all.
Thanks, Gwen. Thanks all. See ya.